Okay, thanks everybody. Good afternoon. My name is Conn Maciel with the law firm of Conn Maciel Carey. I am joined with my partners Aaron Gelb and Andrew Summer, and this afternoon we're going to be talking about arbitration agreements in employment, new considerations for employers. A little housekeeping matters. First of all, this webinar is being recorded, so if you want to hear it again later or pass it along to colleagues who may have not been able to attend today, we'll be circulating copies of the recording along with all the slides of the presentation to all the participants after the webinar ends today. If you have any questions about the webinar or things that we talk about, feel free to type into the Q&A section of the webinar, and we'll do our best to answer those questions as they come in, or hopefully we'll leave time at the end of the webinar. And with that, we'll go ahead and get started. As I mentioned, I am chair of our firm, chair of the National Labor and Employment Practice, and I am a federal litigator, defend employers across the country in the myriad of employment-related issues at the federal and state level, as well as counsel employers on the A to Z of the employment relationship. My partner, Andrew Summer, heads our California office, and he does a lot of what I do as well, but just under the umbrella of California law. So he's going to bring a very unique and fresh perspective to this topic as it relates to what is legal in California and what employers who have operations in California need to think about if they're going to roll out potential arbitration agreements in other jurisdictions. I'm also joined by my partner, Aaron Gelb, and Aaron is the head of our Chicago office. He is a litigator as well as OSHA litigator. Also, similar to Andrew and I, defending employers at the federal and state level across the country on employment issues, as well as advising employers on OSHA and workplace safety issues. So here's today's agenda. We're going to start with a background of what led us to today's topic, the Epic Systems Corp. Versus Lewis. That's a Supreme Court decision that came down last month that really led to why we're talking about this issue today. And we're going to talk a little bit about what this really means for employers. So it's not really been too much back dive into what's happening and what led us here, but really what does it mean for employers? Talk through the pros and cons of arbitration, some practical considerations that you may want to think through about an alternative dispute resolution mechanism if you don't have one in place in your company. And then, as I mentioned, Andrew's going to close with some California-specific issues. So with that, I'm going to turn it right over to Aaron to start off on the background of the Supreme Court decision.
Thank you, Kara. And like Kara said, we're not going to spend too much time on talking about how we got here, but we certainly think that it is informative and worth spending a little bit of time discussing just to give you all the background. So the Federal Arbitration Act, which was passed almost 100 years ago, back in the 1920s, requires courts to enforce agreements to arbitrate, including the terms of arbitration that the parties select. And over the years, cases have come before the Supreme Court presenting various issues relating to arbitration, including one not that long ago that held that class action waivers in commercial contracts were enforceable. So those are the sort of the language you might see in a cell phone, a mobile carrier agreement, or other things that can have a bit of a one-sided feel to them, but those waivers have been held to be enforceable by the court. Historically, though, this issue, as far as in the employment context, has never made it up that far. And perhaps even more interesting, throughout its history, and courts have long recognized and have this preference for the enforceability of arbitration agreements. Even the General Counsel of the National Labor Relations Board, in a memo issued in 2010, acknowledged that arbitration agreements were enforceable in the employment context. Then, in a rather, I would say, surprising and abrupt about-face, the board held in D.R. Horton in 2012 the sort of about-face that I think prompts webinars like this and alerts from law firms because it was such a significant change. The board suddenly reached the alternate conclusion that no, you cannot, as an employer, require your employees to arbitrate class claims because those class claims, class action claims, involve the protected concerted activity that is protected by the National Labor Relations Act. And is often the case with matters that end up before the Supreme Court, you had different circuit court, federal appellate courts reaching different conclusions. And what happened here in the case that we're going to be discussing, in the Epic Systems case, it really was 3 cases that were consolidated together and came up before the court. So the one that ended up on essentially the lead, Epic Systems, Epic was a healthcare software company that required certain groups of employees to agree to bring wage and hour claims only through individual arbitration and did not permit collective arbitration or collective action in any forum. Jacob Lewis, who was a technical writer at Epic, had a dispute and, as is often the case, did not proceed under the arbitration clause, and instead he filed suit against Epic in federal court, contending that the company had violated the Fair Labor Standards Act as well as Wisconsin state law by misclassifying him and fellow technical writers, thereby depriving them of overtime. Epic sought to enforce the arbitration agreement and compel individual arbitration, and Mr. Lewis and his attorneys responded to that, arguing that the arbitration clause violated the National Labor Relations Act because it interfered with the employee's right to engage in concerted activity. In that case, the Seventh Circuit concluded that the agreement did violate the National Labor Relations Act and was also unenforceable under the Federal Arbitration Act, thereby affirming the district court's denial of Epic's motion to compel. Meanwhile, Murphy Oil was a case that had come up through the National Labor Relations Board, and the board there had held that Murphy Oil, which operates a number of oil change type facilities around the country, had unlawfully required employees at a facility in Alabama to sign an arbitration agreement, waiving their right to pursue class and collective actions. Murphy, obviously aware that the Fifth Circuit had previously held to the contrary, using the rights that it has when appealing a decision from an agency, the board, brought an appellate action in the Fifth Circuit, and there the board, interestingly, tried to kind of circumvent that process and go directly to have the matter reviewed by the entire Fifth Circuit. That failed. It was reviewed by a panel of 3 judges, and following the precedent of the Fifth Circuit, they found in favor of the company and rejected the Labor Board's arguments. Last but not least, Ernst & Young versus Morris involved claims brought by Stephen Morris, who was a junior accountant who brought a class and collective action against E&Y in federal court in New York, accusing the company of misclassifying himself and a number of other employees. The case was eventually transferred to the Northern District of California, where Ernst & Young moved to compel arbitration pursuant to the agreements that Mr. Morris and others had signed. There, the court ordered individual arbitration and dismissed the case. Mr. Morris appealed to the Ninth Circuit. There, the Ninth Circuit reversed, finding in favor of Mr. Morris, and remanded the case back to the district court. So as you can see, different courts have reached very diametrically opposed opinions. And so the issue that came up to the Supreme Court then was whether the National Labor Relations Act, which protects the rights of employees to engage in concerted protected activity for mutual aid, and I'm sure many of our listeners have heard us discuss those rights in other contexts, whether it's handbook policies or social media. Here the question is that right to mutual activity, does it override the presumption in favor of arbitration? And what was interesting about that was the Federal Arbitration Act preceded the National Labor Relations Act. And so one of the issues that the Supreme Court looked at was, because the National Labor Relations Act, which came about a decade after the Arbitration Act, didn't necessarily or didn't directly address that, was there still some aspect to it that overrode the Federal Arbitration Act? And as you may all have seen, the decision was a very clear ideological split. It was a 5-4 decision. The majority opinion was written by Justice Gorsuch. He was joined by Justices Alito, Thomas, Kennedy, and Roberts. And then in a rather vigorous dissent penned by Justice Ginsburg, she was joined by Justices Kagan, Sotomayor, and Breyer. What was, I think, interesting in Justice Gorsuch's opinion is he noted that the policy behind these laws is debatable, but the law is clear. And the conclusion that the majority reached was that the National Labor Relations Act, while securing employees' rights to organize unions and bargain collectively, says nothing about how judges and arbitrators must try legal disputes that leave the workplace and enter the courtroom or arbitral forum. Continuing, the court made it very clear that it has never read a right to class actions into the National Labor Relations Act, noting that for 3/4 of a century, neither did the National Labor Relations Board. And that far from conflicting, the Arbitration Act and the NLRA have long enjoyed separate spheres of influence. So in terms of conceptualizing the issues here, you really, I think, from the majority's perspective, that really is a very clear dividing line, that the National Labor Relations Act protects the right for employees to engage in these sorts of activities, whether it's collective bargaining, whether it's the grievance process, when they're at work, when they're dealing with issues in the workplace, when they have disputes that spill beyond the workplace involving compensation with disputes with the employer. That's where the dividing line has essentially been drawn. And if an employer has entered into an agreement with its employees to require those disputes to be heard through arbitration, we now have obviously very clear decision from the Supreme Court that those agreements will be enforceable. And so now I'll turn it back to Kara to talk about, I think, where we go from here.
Yeah, so what does this decision mean for employers, particularly employers who waited out this game of whether to have an arbitration agreement for their employees as a condition of employment upon hire, upon acceptance of an offer? Now that there's clarity from the U.S. Supreme Court, what should employers be doing? And I think sometimes there's an automatic rush that says, oh, let's immediately go to arbitration. Let's have arbitration for all of our employees. But I think it's an open question. Certainly the most important part of the decision that came out relates to class action waivers. And that's a key part of any employment agreement with respect to wage and hour FLSA claims. So now what the decision says is, look, as a condition of employment, you can require your employees to go to arbitration and arbitrate only their claim. They cannot arbitrate a class or collective action. And so it's going to incentivize or really de-incentivize employees potentially from gathering collectively and going to arbitration for a collective action, class action on unpaid wages, or for violations of the tip credit, or for off-the-clock work. And particularly, those types of claims are what is most prevalent in the federal court system with respect to class actions. FLSA claims are the #1 filed claims in federal court than any other employment-related dispute. And so now in most FLSA claims, are done as a collective action because it might just be a few $1,000s for one person, but if you misclassified one person and it affects hundreds or thousands of other employees, now we're talking about potentially millions of dollars in exposure. And so there's real incentive now and an opportunity for employers to take advantage of this decision if they'd like to require their employees, particularly with respect to wage and hour claims or other type of systemic discrimination claims, equal pay claims or other systemic issues, to go to arbitration on an individualized basis. Now that means, do you have 500 individual arbitrations? Maybe, but I think the plaintiff's bar is certainly going to rethink whether it's going to be cost effective and efficient to bring multiple individualized arbitrations to arbitration. And also too, I think part of what's attractive to the collective action procedure for wage and hour claims is you can go into court with just one person and file a collective action and then file a motion for conditional certification. And the way that the courts have ruled that sort of initial step is that you automatically then get class notice. And all of a sudden the notice of this case gets sent out to all of your current and former employees then they fall within the class, and that's how the class generates from one person to hundreds of people. And if that procedure is taken away in arbitration, you're really going to be litigating, I think, much smaller individualized cases. Even if it is more than one or two or three, it certainly isn't going to be hundreds at the same time. The second really important issue, though, is on the flip side, realize this isn't, this doesn't mean that you don't have to address other types of employment-related claims outside of the arbitration context. You're still going to have agency investigations that are unaffected, whether you filed with employee files with Title VII or they filed with the state equivalent. Here in D.C., the D.C. Human Rights Act, you can go to the Office of Human Rights and you can have an investigation that runs concurrently at the same time with the EEOC. And so those agency charges will continue, and those will continue to be investigated. It's only when those would result in a finding of probable cause or a no finding of probable cause, and you've got 90 days to file suit, you would then move from the agency investigation to the arbitration proceeding. It also doesn't prevent, as we've talked about, just general agency enforcement. I mean, we still have federal agencies that are going to enforce their laws, regardless of whether they have, employees that are bringing private complaints. So OSHA or the Wage and Hour Division of the Department of Labor, or again, the EEOC on a systemic or commission-style charge. Those agencies are still going to investigate their laws, and so realize that's not going to stop either by this decision. And then sort of as we talk about, really get into the substance of the presentation, just because you can have an arbitration agreement, the question is whether you should. You want to think about what this means for your company alone. Arbitration agreements may be good for your company or good in some situations, but they're not necessarily a fit for everyone. And it definitely is not a one-size-fits-all type of agreement. You want to craft that agreement. You want to work with counsel to craft that agreement that is specific and unique to your company based on the size of your company, the type of workforce that you have, the industry that you're in, whether you are a private employer or a unionized employer, whether you've got, elements that might be susceptible to class claims. For example, if you're in the hospitality industry and you share in tips, you've got tip pooling regulations, which are very difficult and challenging to comply with. Or if you're in the healthcare space and you've got employees that are paid different rates at different times, at different days of the week, and you've got to allocate all of that for purposes of overtime at the end of the week, those types of claims lend itself easily to class and collective actions under the Fair Labor Standards Act. So you want to think through whether this is something that's right for you. I have to say, I'm a business owner myself. We have 17 lawyers in our firm across, as you can see, across the country, from Chicago to California to Atlanta to D.C. And arbitration agreements don't fit for us. That's just not an industry. We're not in an industry, nor are we a size. We're a professional services company. So I don't think that for our company, we're not going to jump right into arbitration agreements. But for other companies and for many of you on the line, it may be a really viable and attractive option. So let's go through the pros and cons of arbitration. And for the pros, I'm going to turn that over to Andrew.
Thank you, Kara. When we broach the subject of arbitration for clients, we typically go through these pros and cons so the client can have a good sense of what to expect in electing arbitration. There are pretty broad ramifications here and very significant consequences on both sides. The one factor that's not listed here, of course, that Kara touched on is the issue of class action waivers, and that's something that's a huge plus in electing arbitration, since you can have an agreement that would effectively preclude class action lawsuits in either arbitration or in court action. Another really significant consideration is lowering your attorney's fees. When you litigate in court, there is not the streamlined structure that you would have in arbitration. And if you are in state court, such as in California, you're going to have a judge that's going to kind of meander through the case, allow various discovery battles, and ultimately you may not get to trial on your first shot. You may have to have various trial calls, go out, spend the time for your attorney to be prepared, and then go to the trial call and find out there's not a courtroom available. Or have the issue about you have a jury trial and there's going to be a 1-week selection process that involves considerable time until you can select your jury. The judge may, in state court, for example, allow a very long trial, and that's also an additional added expense on the employer side with defense costs. But in arbitration, you'll have a single arbitrator, and that arbitrator will usually set a hearing that's just maybe 2 or 3 days, and that hearing will be more streamlined, and you may have much more, generally you have much more limited discovery that's allowed in arbitration. And then another really important consideration is what we've referred to here as the emotional fueled jury verdict. If it is a case that has facts that could kind of inflame the passions of the jury, that's a case where you'd much prefer to be before an arbitrator. And that could be, for example, a harassment case, any kind of case with salacious facts, possibly whistleblower cases, and you'd much prefer in those situations to be before an arbitrator. Even if you don't ultimately win, you're less likely to get that much higher verdict that a jury could award that may be detached from the actual facts in the case. And also, as touched upon, there is a much speedier resolution in arbitration than in court. You can get an arbitration to a final hearing within 6 months. In a state court, it can take years. In federal court, it would take at least a year. And then turning to this slide here, the other considerations here in terms of the pros is the flexibility that you have in arbitration. An arbitrator is much more likely to defer to the scheduling availability of the attorneys and the parties, whereas in trial, the judge reigns and you may not have a lot of flexibility about when you end up in trial. And also another plus, if you are the employer and you prevail in arbitration, is there's very limited recognized appeal rights in arbitration, and you're not going to have the prospect, at least as likely, of a frivolous appeal being filed with the state court or federal court. There's just very few instances when that would be entertained. For example, in California, there has been a court recognizing a right to appeal over an issue of a statute of limitations where the claim wasn't even allowed to proceed. But outside of that, there's been very few opportunities for appeal that have been recognized in the arbitration context. Now I'll turn it over to Kara to discuss the flip side here.
So yeah, I mean, for that exact same reason, I also think that, having a final decision, if an employer loses in arbitration, the grounds upon which a court could review that decision is limited. And I'm not sure that's a pro or, which could be a con, really, because it tends to be more, it really tends to challenge your ability to get that appeal if you feel like you've been wronged by an arbitrator. It's also very much more difficult to get dismissal or summary judgment in arbitration than you are in court. On employment matters, particularly here where I practice in the Fourth Circuit area, we like our courts. We get motions to dismiss and motions for summary judgment granted routinely. Very rarely does an employment case now go to jury verdict unless there's a strong factual dispute between the parties. But courts in Washington, D.C., federal courts in Maryland, courts in the Fourth Circuit, there are high standards of review for purposes of how to show pretext, and very few of those cases make it through to summary judgment stage. So at the arbitration stage, the AAA rules, for example, provide that an arbitrator may permit a motion for summary judgment if the moving party has shown substantial cause, but it's not required. Motions are not provided as a right like they are in the federal court system, so you're giving the arbitrator a lot of discretion as to whether and when to obtain those kind of really important procedural issues. And so as a result, you might not be able to narrow the issues at the outset of a lawsuit or at the outset of an arbitration proceeding as you otherwise would be able to do in court with motions to dismiss. Even if it's a partial motion to dismiss certain claims. Let's say you've got a case where someone is alleging, hostile work environment under Title VII, but then they add in, tortious interference or negligence or intentional interference for emotional distress, or some claims that by law immediately are preempted by the workers' comp statute, for example, or don't have a basis in law or fact. And even while maybe the hostile work environment claim may continue through to discovery, you'd want to dismiss maybe some of these other claims just to narrow the issues for discovery. And if you don't have that availability at arbitration, you're going to be ending up going through discovery on frivolous issues, which could, again, make things a little bit more expensive, which is kind of why I necessarily don't think that arbitrations are all that much more cost-effective than litigation. Here you've got arbitration fees. The cost of initiating arbitration is higher than the cost of a lawsuit. But again, given the flexibility that the arbitrator has over the discovery process, they're not bound by the rules of civil procedure. So they could allow 10 to 15 depositions, or they could allow third-party depositions, or allow a lot of discovery or expansive document production, motions to compel. That could allow for defense costs to be much higher than litigation, where you've got a federal court or a federal magistrate that is focused on the discovery process and making sure that discovery is fair and reasonable, but it's also closely managed. So I'm not necessarily sold on the idea that arbitration is a lot cheaper. I also think there's a very strong and pretty valid perception that arbitrators split the baby when ruling on issues in appeasing both sides, right? An arbitrator is a professional. He or she is being paid for their time. They want to stay on the panel of arbitrators, and while they're going to rule on the issues, they're not bound by precedent. They don't have to follow Supreme Court law. They don't have to follow, what other courts in that jurisdiction have done. And that allows them to craft and create solutions to appease potentially both sides. And that might not always be the best situation for an employer. And then the last thing to think about is, the increased volume of claims. Some people believe that if employees are unable to proceed, then they're going to face a barrage of individual arbitration demands. And that was something that I touched on earlier with respect to the likelihood that there'll be, hundreds of individual arbitrations. I don't think that's the case. I mean, we work with a number of clients across the country that have pretty sophisticated alternative dispute resolution issues, and they, goes from a peer review process to a manager review to mediation before it gets to arbitration. And because there's so many different steps that allows the parties to work out their dispute before getting into arbitration, the number of arbitrations is very, very small. And so I think it depends on how you want to go forward with your arbitration plan and your ADR process in order to make sure that you're not going to be in a situation where you've got a barrage of individual demands. I think the ability to resolve those before they get to arbitration allows you to prevent that, as well as I just think individual lawyers, the plaintiff's bar, maybe sophisticated, well-known, very strong plaintiff's lawyers that are skilled could be able to do that. But for the majority of the solo practitioners that represent individual plaintiffs, I just don't see that that is going to be an issue. So let's talk a little bit about, now that we've talked kind of the pros and cons, really, what are some practical considerations you can take back to your companies and talk about this with your C-suite about whether this is something you want to be doing going forward?
Thanks, Kara. And like Kara said, just like arbitration agreements may not be for everyone, there's no one-size-fits-all as far as the type of programs or policies that you may decide to roll out. In the process of making that decision, when you go back to leadership and have this discussion that Kara just referenced, there are a number of things that practical considerations or things that you're going to want to discuss and figure out before you roll it out, because this is certainly not something that you want to rush into, in my opinion. I think there's been such a build-up to this case. Employers, as we've said at the outset, employers have been waiting with bated breath for this decision to come down. I think everybody, at least a lot of us, expected it to come down the way it did. And I think I feel like for years we've been advising clients, one day you're going to have the ability to roll out a program that will enable you to compel arbitration even for wage and hour claims. So there may be some people out there that have a program fully baked, and you're just, all you have to do is hit send or mail out the agreements, and you're ready to go. I assume that employers like that are in the distinct minority, and that most people have been waiting to see how this shakes out before investing the time and resources that would be involved in developing such a program. So one of the first considerations is fairness. This isn't just because the Supreme Court has blessed these sorts of agreements doesn't mean that you can just go out and roll out any type of agreement that you want. These agreements are still going to be subject to, in essence, the laws of contractual formation and analysis in the various states in which you operate. So a court can still void an agreement if it's deemed to be unconscionable. And there are generally two types of fairness that are recognized. There's procedural fairness and substantive fairness. So procedural fairness deals with how the contract was formed. And believe it or not, in many states, you actually have to agree to a contract in order to be subject to it. I think just about 12 days ago, an employer in California, a large manufacturer, attempted to compel arbitration in a case brought by a temporary worker, someone who was claiming racial harassment during his assignment to that company's manufacturing facility. He then received an employment offer from the company. He did not accept it, and when he sued based on the alleged harassment that he claims occurred before he got that offer of employment, and the company moved to compel arbitration, saying, well, we extended this offer of employment to him and included an arbitration agreement, but he never agreed to it. And the California court, decided that no, you cannot compel this individual to arbitrate these claims because he never agreed to do so. And I think the comment from his attorney was something to the effect of arbitration does not happen by osmosis. So when you're rolling out a program, you want to make sure that when it's sent out, whether it's electronically, whether it's in paper form or it's handed out to people, that you actually get signatures on the agreements. That you have a way of tracking if it's done electronically, whether it's read receipt, and there's some sort of evidence that is generated that every employee has read it and has clicked the agree button. I think we've all been had cases where the one person who didn't sign the authorization form, the employee handbook, and the sexual harassment policy is the one person that sued. So you want to make sure that the folks that are administering this program are doing their due diligence to making sure that everybody who has received it has signed it. So it's certainly not the sort of thing that you want left to chance. The reference to arbitrability being left to the courts is, again, if there's some question as to whether or not the agreement is procedurally fair, whether the agreement is arbitrable, that is a decision that will likely be left to the court. So you're not going to get to go into arbitration and let the arbitrator decide whether he or she is going to hear that matter. With respect to substantive fairness, again, we're looking for agreements, and if you hire counsel, obviously that their goal is to draft an agreement that is not one-sided, because that sort of agreement is likely going to be held to be unenforceable. So what you generally are looking at here is one of the primary considerations is, does the employee still have the ability, do they retain the ability in the arbitration forum to prove their case? If you roll out a plan that has significant limits on their ability, on the employee's ability to propound discovery, so they can only serve 5 interrogatories or requests for documents instead of the 25 interrogatories that are allowed in federal court. If they cannot take depositions, or if depositions are limited to, if you try to say, oh, all depositions are limited to 30 minutes, or any sort of limitation that makes it impossible for that person to prosecute their claims, that's going to be the sort of red flag that is likely going to make it very easy for a court to deny your motion to compel arbitration. You also have to make sure that the remedies are the same as the employee would have in court, and that obviously can vary depending on the laws that the person is bringing the claim under, the forum in which they're bringing the claim. So obviously, and Andrew may be talking about this later, the types of remedies that are available to someone suing in California can be quite different in terms of the damages available than someone suing here in Chicago. So if you think, well, we're gonna put a cap, Title VII cap is $300,000. We're going to limit recovery to $50,000 per claim. That's a very quick and easy way to ensure that your agreement is not enforceable. You also cannot change the statute of limitations if an employment law allows someone to bring a claim, say under Section 1981, within 4 years. If you try to put something in the agreement that says no, all these claims have to be brought in 1 year, or you can only bring a claim within 30 days of your termination, things like that, I certainly think that those will also lead to an unenforceable agreement. So assuming you draft an enforceable agreement, one that complies with the considerations that I just went through, then you start looking at what sort of agreement do we want to have. Are we going to have one that is an opt-in? And again, these all may not necessarily be available depending on the state contract, the contract laws of the state in which you're operating. But I expect that there may be employers that are going to proceed under a system that every employee, as a condition of their employment, is now subject to this arbitration agreement, and in order to not, you have the option, though, to opt out. You don't, obviously, as an employer, you don't have to provide that option, but there may be employers, as Kara said, for employee relations reasons, decide that we're going to allow people to opt out, whether that's from a PR perspective or employee relations perspective, for some reason that perhaps you're not going to make it mandatory, but you're going to presume that everybody's in, but let them step out. Or are you going to have a voluntary arbitration program, which gives the employees the right to go either route? I've seen clients that go both ways. And interestingly enough, a couple of the clients that have those voluntary or opt-in programs where the employees have either option, we don't really see a preference necessarily for one or the other. We handled a number of arbitrations for one client, but given the size of their workforce, it's a pretty small percentage, even though this cheaper and faster avenue is available to them. Certainly, in today's era, with the the various operations that you have throughout the country in different regions and different cities and states, you may decide that we only want to have certain employees, certain classes of employees that we are going to require to arbitrate their claims. You may make the decision that requiring your salaried, or your non-exempt employees, your hourly employees to arbitrate is a bad look, or it's going to create too much discord. I think, as Kara said, or maybe it's going to encourage people to unionize because they're so upset about this decision. So you decide we're only going to have our exempt or salaried employees or managers. They're the only ones that are going to be required. Perhaps there's a certain facility that, for one reason or another, it's been a hotbed of claims, or the workforce there for some reason is problematic. So we're going to do a test case, or we're going to try an arbitration policy at this location only, or in these states or regions. Obviously, if you do something like that, that can, because employees still do have the right to engage in protected concerted activity about their working conditions, that may lead to employees protesting or organizing or doing so things along those lines. So you certainly still have to be mindful of what will be the impact if we decide to go this route where we're not rolling out a policy that applies across the board. Another interesting alternative, and one that if Kara, if you wanted to chime in, because I know you've got probably more clients that do this than I do, there's this concept of a jury trial waiver, which from the perspective of some employers may be the best of both worlds. So this is something that you might include simply as a policy in a handbook, and it provides that employees waive their right to a jury trial, meaning that, which is I think the one area where very few, if any, employers would ever like to find themselves, and you're defending yourself in front of a panel of jurors who, as I always like to say, probably several, if not all of them, have had a negative experience with an employer at some point in their life, or they've had a family member who's either currently very unhappy with their employer or has been in the past. So this waiver enables you to remain in the court system. You still get the opportunity to go in front of. So if it's in federal court, I think most lawyers I know certainly find that federal judges to be the cream of the crop, so to speak, and in many cases may be preferable to arbitrators. You're not dealing with some of the cons certainly that Kara talked about as far as an arbitrator splitting the baby. You have access to the federal rules of civil procedure, meaning that right to file for summary judgment that may not be accorded to you through the AAA rules. You've got the right to appeal an adverse decision that's issued by a judge, and you're taking out that potential by removing the right to a jury, the emotion and runaway jury verdicts that we talked about. So it certainly is something. I know I've had clients that have said from time to time, if we could try this case to a judge instead of a jury, we'd forego summary judgment. We would be happy to try this case in front of a jury, but we just don't like the idea of trying it in front of a judge. We don't want to try it in front of a jury because for whatever reason we're very concerned about that. So this is something else to consider.
Aaron, if I could add one point.
Yes.
For California, a jury trial waiver is unlawful unless it's in connection with, for example, an arbitration agreement where it's a non-judicial forum. Just something to keep in mind there.
Thank you. Yeah, and I think and that's a good point here in Illinois. As we like to say, we're not California, but we're trying to get there. Certainly not weather-wise, but employee protection-wise, it wouldn't surprise me to see other states follow in California's footsteps if this is something that becomes more and more common. So another set of practical considerations, if you're not going to be limiting the employees, the types of employees that are subject to the agreement, are you going to limit or carve out certain claims? I think in light of the Me Too movement, you're already seeing certain states, and there's talk of federal legislation as well, that might say that the Federal Arbitration Act does not apply to sexual harassment claims. That there's law in New York which is prohibiting this. So, but then you can kind of draw your circles a little bit larger and start asking, well, are there other groups, again, from a perception standpoint? If we're not requiring it of sexual harassment claims, what about pregnancy? Are we going to look bad if we're requiring a pregnant employee who's been denied an opportunity to promote or to move into a different position? Should we carve those claims out? What about military status claims under the Uniform Service Employment Rights and Reemployment Act, USERRA? USERRA is one of the most employee-friendly federal law out there that protects the rights of service members both to take leave and return to their jobs at the end of their service. Do we want to look like we are pro-service members, so we're going to carve those out as well? Or maybe we are only going to include the arbitration agreement or require it for wage and hour claims. As Kara said, that's the most common claim. Maybe you're not worried about EEO claims, but you run a restaurant or a hotel, and your overwhelming largest risk is wage and hour claims, so we're only going to require it there. So that there are a number of different areas where you can draw that line, and it's just something that you should think about strategically and decide how these types of agreements best fit your workforce. And I think Andrew, I'm going to turn it over to you there.
Okay, so I was going to discuss some dispute resolution programs that can be considered either in concert with the arbitration process or alone. But when you look at dispute resolution processes, you want to look at what's the goal of the program and what is your corporate culture. For workplaces where there's a desire to discourage arbitration and have it or court proceedings and have those be the final step in the process, there may be an interest there to have some sort of intermediate step, and that can be proceeding through internal complaint mechanisms within the company. That can be through an open door policy or otherwise. And then other goals that can be considered are ensuring that employees feel that they're being heard, and that may make it more desirable from the employee standpoint to have some sort of voluntary alternative dispute resolution process before they get to court or arbitration. Or the employer may have the goal of just creating a mechanism to avoid claims, and that can allow for internal grievances and possibly mediation that would then discourage or avoid any claims from then being filed. And then you also want to look at the corporate culture. There may be workplaces that have a very strong culture of welcoming complaints and feedback from employees. And if you do adopt an arbitration agreement, having some sort of an intermediary step that requires exhausting complaints internally, possibly going to mediation, may be desirable to workers. Where there are labor management concerns and lots of possible grievances, you may want to weed through them and explore possible resolution before an employee has the opportunity to file a claim or go to arbitration. And so what are the different mechanisms that are available? You may have a 1-800 number where someone could complain. You may have an open door policy, online reporting mechanism. You could go as far as adopting an ombudsman approach or ombudsperson, similar to what public employers have, where you have a individual from the company that's designated to investigate complaints. And that may go a long way in ensuring that the employee complaint is heard and as fairly as possible. And then, possible, pre-arbitration steps that you can consider, and that's on the next slide, is that you can have the first step of appealing through the chain of command. That could be going to your immediate manager or to human resources with the complaint. And then possibly the next step would be going to mediation, which would be a third-party process where it's you have an individual that will help facilitate a resolution, but it's an entirely voluntary process. So we've seen arbitration agreements where there is the step of mediation or internal grievances that's required before you proceed to arbitration. If you do have mediation as an option, you'll just want to keep in mind that this will be an added expense that will need to be assumed by the company. Some companies have adopted a peer review process as another pre-arbitration process, and that is essentially where there is a binding process in which essentially a panel of individuals consider the adverse employment action, whether it be discipline or termination, and make a binding decision. That's typically a group that consists of both management and employee representatives. We have found that to be a favored approach in a industry that is heavily unionized, but in that workplace is not unionized, and there's desire to maintain the workplace as non-unionized. And something to keep in mind is if you have these pre-arbitration steps for grievances, ways for employees to air their concerns, to have a process in place to avoid any situation that could give rise to an inference of retaliation, to have a very beefed up policy against retaliation in the workplace and ensure that the managers of the employee that has made the complaint are aware of their obligation to avoid retaliation and for there to be some oversight over that process. Another consideration here with arbitration is how to roll out that process. You want to make it attractive to workers, and that's on the next slide, but you really want to have proper messaging about arbitration if you are adopting it for the current workforce and not just for applicants. And so the messaging will be very important. How you communicate that, you can highlight the attractive elements here about ensuring that there can be an exhaustion of their claims, whatever they may be, that there is a mechanism that's less formal than having to go to court, and explain if this potentially can be communicated in concert with other company changes. If there are changes in benefits that are favorable to employees, that may be a good time to indicate that there's going to be this arbitration program that's being adopted. And you'll want to emphasize in that communication all of the ways in which you can resolve these potential claims before getting to arbitration, that there are all these internal mechanisms to air your concerns through the open door policy and otherwise. And it'll also be important, or one consideration at least, is to recognize the importance of whistleblowers coming forward. And many of you have policies that recognize the right and expectation that if employees have concerns about, for example, unsafe work practices or other unlawful activity, that they'll come forward and let you know, which of course behooves the company, because then they can address that concern in a way that would avoid a potential claim after the fact. And now, turning to the next issue, which is any sort of benefits that you can provide employees as an enticement to sign the arbitration agreement. And one consideration, though this will not work for many employers, is to adopt something like a just cause termination right in the arbitration agreement to show that you're providing some additional benefit. If you do this, you'll want to carefully draft that just cause provision to make it broad enough that it provides employers the discretion and need to terminate as warranted. And so it would be something ideally broader than what the union definition is of just cause. And this may only work for certain workforces. For example, it may be an employer that does not have a lot of performance management issues, or maybe they have a really comprehensive performance management process with HR oversight to ensure that they can go through the steps to adequately document performance and ensure that they can support that decision should there ever be a need through arbitration or otherwise. Now, the last kind of practical considerations here are, if you're going to adopt an arbitration agreement, are you going to adopt it for only new hires, or is it going to be for all employees? If it's only for new hires, then you really don't have that messaging problem. You essentially require that applicants sign the arbitration agreement as a condition ideally for applying for employment, and there's really not the discussion that you need to have about this or any built-in expectation that could be a problem. But for current employees, if you do have the arbitration agreement apply to them, then there will be the messaging issues that we just discussed on how you communicate this change in employment to them. Another consideration here for arbitration is what service are you going to use? We typically recommend using an established arbitration service such as American Arbitration Service, or American Arbitration Association, or AAA, or JAMS. And before you select one of them, you really want to think about some of the logistical issues and how those arbitration services are administered. A significant difference between the two is that JAMS typically has retired judges as its arbitrators, whereas AAA has more practitioners, attorneys, and also the jurisdictions where they're available. AAA and JAMS are not available in all locations, and there's some where JAMS are located and AAA is not. And their rules are fairly comparable, but there's some differences, such as AAA provides for the striking of names of the arbitrators from a list that's provided for you to arrive at the ultimate selection, whereas JAMS provides for a ranking of arbitrators. And how they define the scope of discovery is a bit different. But this is a much lengthier discussion beyond the webinar for today. But I did want to dive right into the California considerations. California is a hotbed for litigation, as you know, in particular around arbitration agreements. There's been so much litigation around this subject that you have a number of different decisions that carve out all of these different requirements that you must meet to have an arbitration agreement that's enforceable. And I will start out with a discussion of the Supreme Court's decision in Armendariz. And just, to cut to the chase here, that case involved consideration of an arbitration agreement requiring arbitration of claims for discrimination under state law, under the Fair Employment and Housing Act. And in that decision, the court laid out various different elements that are required to arbitrate such a claim. The Armendariz case has been expanded to common law claims for wrongful termination, and there will likely be further litigation over the scope, but we typically recommend adopting these Armendariz factors based on the uncertainty as to what the scope may ultimately be, as to the types of claims that will be encompassed, dependent on future litigation. But the core elements are that you must have a neutral arbitrator. You can't, for example, pick a company official from the employer to be the arbitrator. You must allow for adequate discovery. That's not clearly defined, but the AAA and JAMS do provide broad enough language to and are recognized to satisfy that standard. The arbitration agreement must also allow the employee to recover whatever he or she would be able to recover in a civil trial. So that would be economic damages, emotional distress, punitive damages, attorney fees, if those things are available based on the nature of the underlying claims. There must also be a written decision by the arbitrator, and the employer must pay for all costs associated with the arbitration. The caveat is that if there is a filing fee required in state or federal court that's paid for by the employee, that the employer is only responsible for the costs in arbitration above that typical initial filing fee. And what's really key here is that the agreement must provide for mutuality between the parties, and that's been interpreted to require that if you're going to release claims, that they have to be claims for both the employer and the employee. So if the employer wants to, for example, carve out certain trade secret claims that it can pursue in court against the employee, a California court has addressed that issue, and essentially doing so would make the agreement unenforceable. and there has been an exception recognized for injunctive relief. Essentially, if you're going to court to seek an order by the court requiring that the employer or employee take certain action or refrain from engaging in certain action, that's something that you can carve out as long as it's not specific to certain claims benefiting the employer specifically. And then just moving to some of the other considerations here, the agreement must be freestanding. There's been some litigation over whether the agreement can be incorporated in a handbook, but the best practices at this point is to make sure that the employment arbitration agreement is separate from other documents and is signed by the employee. There has been a case recognizing that an agreement could be enforceable if it's not signed by the employee and the employee's been placed on notice and it has essentially accepted the agreement. But that's a bit risky there, and the best practices would be to ensure that you've gone through the checklist to make sure that all of your employees have signed the agreement. Another consideration is whether the agreement is unconscionable. And that's similar to the discussion that Aaron already had, is that you really want to look at, is it procedurally and substantively unconscionable? And it requires both, and California recognizes a sliding scale, meaning that the more substantively unconscionable the agreement is, the less procedurally unconscionable it needs to be for the agreement to be unenforceable. And so every agreement for arbitration, for the most part, has some degree of procedural unconscionability because you are typically having this agreement provided to an employee on a take it or leave it basis, and it's a standard form. But where employers really get into trouble is when it's substantively unconscionable in California, and that can cause the whole agreement to be made unenforceable. And so that would occur in the situation where you typically have terms that are more favorable to the employer than to the employee, and that can be in the situation that I discussed previously where you have claims that are being subject to arbitration that are possessed by the employee but not the employer, and that you're having a carve-out of claims that benefits the employer. Now, moving to one of the last subjects here, claims that are not subject to arbitration in California. There has been some litigation over the Labor Code Private Attorneys General Act claims, and these claims have really been a thorn in the side of employers in California, and it's essentially a mechanism for employees to bring all of these labor code claims purportedly on behalf of the general public and seeking a host of penalties that previously were not available to litigants. And so these claims are pursued collectively like a class action. And the state of affairs right now on these PAGA claims, as they're known, is that they are not subject to arbitration agreements. And the logic has been that because the claims are being brought on behalf of the California Attorney General, even though by private litigants, that they're not subject to preemption under the FAA. And at this point, those claims do need to be carved out of the arbitration agreement. And there's also an exception as well for workers' compensation and unemployment benefits claims. And presently, there is legislation pending. It's Assembly Bill 3080 that's seeking to exempt from arbitration agreements harassment and discrimination claims brought under the California Fair Employment and Housing Act. If that legislation is passed and makes it into law, I do expect that there will be challenges, and there is a potential that that legislation would be found to be preempted by the Federal Arbitration Act. And now another interesting development in recent years in California has been California's efforts to regulate arbitration agreements. There have been some provisions found to be unenforceable based on federal preemption, and specifically the Labor Code has provided in California for excluding from arbitration claims for unpaid wages. And a court has found that that law is preempted by federal law and therefore invalid. The California legislature, being progressive as it is, has really tried to find numerous paths to undermine arbitration of employment claims. And they've been up against a wall here with the FAA. And, essentially the Federal Act does not prevent states from enforcing certain traditional defenses to arbitration, such as the ones that Aaron and I have discussed over the contract, whether the contract, for example, is unconscionable. But where clearly the state imposes an obstacle to impede arbitration altogether as to certain claims, a court may find that effort to be invalid. And one, there is the issue with the wage claim. But given that the avenues have been limited in California under recent case law, especially in light of the EPIC decision, the California has come up with other tactics, and one that did come down a number of years ago was a law that requires that arbitration services publish information about arbitrations. And one benefit of arbitration has been that the proceeding is private, and that's one that we didn't mention previously, but is significant, that it's typically a private proceeding, or it traditionally has been. The information isn't available to the general public like a court proceeding, where you have a court report taking down testimony, you have the docket, you have all the information available to the public. That has changed to a degree, and now the arbitration services are required to publish information regarding the parties to the arbitration proceedings, the outcome, the nature of the claims, and even how many times the employer has been before the same arbitration services. And so there's a number of other nuances under California law. I think the real takeaway here is that California has a real maze that they've required attorneys and employers to navigate to ensure that the arbitration agreements are enforceable. And given that much of the analysis in California has been around the issue of unconscionability, I do expect that over time other states will adopt similar restrictions as we've seen in California to varying degrees based on a finding that just simply the agreement is too one-sided, for example, in favor of employers. And now I believe we'll answer any questions that have been asked.
Great, thanks, Andrew. Yeah, let's pause for some questions. If anybody has it, takes the time now to type it into the Q&A. We've got a few questions that have come in during the webinar. One is, what would motivate an arbitrator chosen by the employer to split the baby? Wouldn't they want to side with the employer in arbitration? I guess that kind of goes to the question, Andrew, I think you mentioned the differences between AAA and JAMS. The selection process is different, and I think the other side's lawyer, the claimant's lawyer, also has a right. And I'm not sure there's a widespread belief that all arbitrators, just because they may be with a certain arbitration service, would favor the employer. But I'm interested, Aaron or Andrew, what your thoughts are.
Yeah, I think that's right. That because these arbitrators know that they can be stricken, depending on the selection procedures. If it's one where they can be stricken by either side, if they've developed a reputation of being pro-employer, that's a quick way to ensure that they will be stricken by the employee side attorney. So I think that we see it obviously in the traditional labor side all the time. And I think that's one of the main reasons why they split the baby is they want both sides to not a primary reason, but certainly it could be a consideration that they want both sides to be willing to select them again in the future.
Yeah, and I would just add that because of the business dynamic here, in that the arbitrator depends on voluntary selection by counsel through the standards selection process, that they will, invariably, or many will consider the prospect of future business. And I have had arbitrations where, for example, one case I had where it was a pretty weak case for the plaintiff. The arbitrator granted or ruled in favor of the employer on all the significant claims, but left in the harassment claim and awarded a very small amount. And from our perspective, at least, it appeared that that was a desire to appease the plaintiff and her counsel, and a desire, to essentially split the baby for whatever future opportunities there may be had.
Another question came in. If you only have a jury trial waiver and not in an arbitration agreement, what kind of document would you put that in? I think I've seen it. I've seen it in both in an offer letter, and I've seen it listed in an employee handbook, where that you make it very clear, upon acceptance of the offer, that any claims, any employment-related claims that may be brought are not subject to jury, and that also is reiterated in an employee handbook.
Yeah, I think kind of consistent with what we've been discussing, that because this could be dependent on various state laws, is to make sure you check with counsel to find out how such an agreement would be perceived by or analyzed by the courts of the states in which you're operating. I know that there have been decisions in the Third Circuit and in New Jersey state courts. So I think that certainly could, in many states, what you described, Kara, would work. There are probably others where it would not, and you may the bet in those, or the approach in those jurisdictions would be to proceed with something akin to an agreement that is actually signed by the employee.
Okay, well, it looks like we are over our time. Thanks everyone's patience today. As I said, we are recording this webinar, and if you want to check out future webinar series or other hot topics that our employment group and OSHA Defense Group works on, please sign and register for our blogs. But we appreciate everyone's time and attendance, and hope everybody found this webinar to be useful and with good tips to bring back to your company. Thank you.